So let's talk about direct threat, because this poses a very different issue with respect to defining the legal standard for fitness. Courts have consistently ruled that an employee who poses a direct threat to oneself or others is not otherwise qualified under the terms of the ADA. Remember that the ADA protects qualified persons with a disability, persons with a disability who are otherwise qualified to perform the essential functions of the job with or without accommodation. If, however, you pose a direct threat to yourself or others, you are not under the ADA otherwise qualified. Consequently, no accommodation is required, even if the threat results from a disability. That's the general finding across the courts. The difficulty comes in defining what constitutes direct threat. So let's talk about that for a moment. Now, those of you who work in the VA system and evaluate VA police officers have a different standard entirely. So let me take a few moments to talk about that. The Code of Federal Regulations 339.301 states a federal agency may order an employee to submit to a psychiatric or psychological examination only when, one, a properly ordered physical examination indicates no physical explanation for behavior or actions which may affect the safe and efficient, they say efficient as opposed to effective, performance of the individual or others, or a psychiatric or psychological examination is specifically called for in a position having medical standards or subject to a medical evaluation program. So, when a police officer in the VA system is being referred for a fitness for duty evaluation, they have to first send them to a physician to be evaluated and rule out a physical explanation before they can proceed. Multiple court cases have reached that conclusion. One as recent as, I believe, last year that I can send you, I don't have it with me, where they skipped that process, referred them for a psychological evaluation without first ruling out the physical condition. Okay. So 339.301, we've got 339.206. A history of a particular medical problem may be the basis of a medical disqualification only if the condition at issue is itself disqualifying, recurrence cannot medically be ruled out, and the duties of the position are such that a recurrence would pose a reasonable probability of substantial harm. That's the standard in the federal system. It's very, very different than under state law, or very, very different in the standard of practice for fitness for duty evaluations. It's the federal system. So you need to be sure that in whatever jurisdiction you're working, you need to know if there are any statutory or policy or regulatory directives that would paint the contours of the forensic question and the definition of fitness, or in the case of this, direct threat. So here's the federal standard for direct threat. This comes from a case of Lassiter versus Reno, as in Janet Reno. Given the duties of a deputy marshal, a significant risk to the safety of others can arise not only from an inclination to strike out in violence, but also from a tendency to misperceive the true nature of events. Placed in unfamiliar circumstances that may or may not be hostile, the deputy marshal must have the ability to decide in an instant whether the use of deadly force is warranted. If an innocent person is injured or killed because a deputy marshal read threatening meanings into benign remarks or events, it is not difficult to imagine the public outrage, let alone the potential liability to which the federal government would be subjected. This is a case involving a paranoid deputy marshal. Now, the relevance of this, you'll see in a moment, but let me just kind of skip ahead a little bit, is that the federal standard in ADA is that a direct threat means a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. Significant risk of substantial harm. That is further defined by the EEOC as significant risk means highly probable, not simply more likely. So 51%, is that high? More likely? They haven't defined it. But it is highly probable, is what the EEOC says. Now, under the interpretation of Lassiter, that is further clarified, as you'll see here in a second. In assessing whether an employee can perform his duties without significant risk to the safety of himself or others, we must consider the nature of the position and the consequences should the employee fail to perform his duties properly. Now the question is being constructed in such a way that it's not a matter of across the board of whether the person's behavior is highly probable to cause substantial harm to others, but it's an interaction between their particular problems and the nature of the job. What case did that sound like? Remember EEOC versus Amigo. Cody as well. Brownfield versus Yakima, where the court said, you know, we normally wouldn't refer a person for fitness for duty evaluation unless there was some impaired performance on the job. But in the case of a police officer, we don't want to wait for their performance to fall apart when we have non-performance data that suggests we may very well get to that point. So a preemptive fitness for duty evaluation was called for in the case of a public safety employee. Here again, the courts are saying, let's not be held to this highly probable definition of direct threat when we're talking about a police officer. So, yes?
So, for you, do you then differentiate between a fitness and a threat assessment? Or for you, is that medical evaluation?
Do I differentiate between what, Jocelyn?
Using the terms of a fitness for duty or a threat assessment or a risk assessment, or is it really...
The question is, do I differentiate between a fitness for duty evaluation or a threat assessment or a risk assessment?
In an employment situation.
I differentiate in this respect. Certainly those terms are often used by an agency. I don't force them to adopt my language. I accept their language. It is still a compulsory medical evaluation, and I'm happy to use their terms, but all of the protections, all of the procedures that I would follow regardless of what language they use. If it's a compulsory medical evaluation of an incumbent employee, it is going to be the same procedures. I'm going to follow the same methodology, but I'm going to use their language, and it defines the scope, pardon me, it defines the scope of the forensic question. If it's a threat assessment, I'm not assessing whether or not they can perform the essential functions of their job effectively. I'm only trying to determine whether or not they pose a risk to themselves or others. So the forensic question changes. I'm not going to do a fitness for duty evaluation that focuses on broadly on can they perform the essential functions of their job, when the only question posed to me by the employer is whether they pose a substantial threat to others in the workplace. So these are cases that I would encourage you to take a look at some point. These are cases where the plaintiffs were deemed to be unable to perform the essential functions of their job without posing a significant risk to the health or safety of others because of a disability that could not be eliminated by reasonable accommodation. It includes an HIV-positive surgeon, a diabetic bus driver, an FBI radio dispatcher with bipolar disorder, and an alcoholic FBI agent. So only persons able to perform the essential functions without posing a direct threat are qualified under the ADA. We've talked about what direct threat means as defined by the Code of Federal Regulations, and that normally that it requires a significant risk, meaning that it's highly probable, not simply more likely. But there is a balancing analysis that occurs with public safety employees. And the courts have said this: where the potential harm is severe, even a low probability of harm will be sufficient to establish a direct threat defense. Meaning, the defense meaning that you didn't violate this person's right under ADA. It's because they pose a direct threat to others. So that's the direct threat defense that is awarded to the employer. Conversely, where the potential harm is not fatal or catastrophic, the employer will usually be required to clearly demonstrate that the risk is highly probable. So this interaction effect, particularly when you're analyzing direct threat, is not simply what's the risk that the person will engage in this behavior, but what's the consequence if they do? If we can keep it short, Victoria, because I got to move through.
This would not then apply to police officers.
This absolutely applies to police officers.
But
Where the potential harm is severe.
Is catastrophic.
Absolutely, that's what it says. Where the potential harm is severe, even a low probability of harm will be sufficient to establish a direct threat defense. Not the defense on the part of the plaintiff,
The converse, okay.
the defense on the part of the employer.